good morning, everyone. Good morning. We are going to start here. Good morning. If we could thank you so much. I want to take this time to introduce the president of Cleveland State University, who will bring welcome and go over what's next for you. So let's welcome President Berkman to the stage.
Thank you, Maurice, and thank you all for being here with us today. I want to thank, firstly, the student organizations, the faculty organizations, the staff organizations who are here today participating, but I also want to make special mention of the community organizations that are here today and have been here, in this incredibly woven community, the civic fabric of Cleveland. I hope I don't miss anybody. The Anti-Defamation League, the LGBT Community Center of Greater Cleveland, the Diversity Center, Equity Ohio, the Hispanic Alliance. At the end of the day, in my estimation, the most significant antidote for hate is unity. That is going to be what is going to be the determining factor. And what we are here today, and what we see here today, is unity. The ability to build this coalition, represents an incredible step forward. I want to thank the panelists for being here. Judge Williams, thank you so much for being here. Kevin O'Neill, thank you very much for being here. Lee Fisher, who's going to moderate it. I just want to take one more minute, to talk about some of the things that we of a university have continued to do after the posting of the vicious, toxic hate poster that appeared several weeks ago. At the November meeting of the Board of Trustees, we will bring to our board to codify as university policy the preferred name policy, which was in motion and was going to be a college policy, but will now be a codified Board of Trustees statutory policy. We have, yes, I think it does. And credit to Chairman Bernie Moreno, for helping us push this and get the support of the board behind this. We have ramped up security at the LGBTQ plus center, new cameras, graduate assistance, increased graduate assistance, controlled access, etc. We have, as you know, as I'm saying, connected with the larger community. We are looking at all our university policies, and I think we're going to talk about this today, to make and tighten all of the policies to prevent or respond to effectively, the kind of actions that we saw a couple weeks ago. 4 gender-neutral bathrooms have been opened at the university, and again, this has happened, in the relatively recent past. But I repeat, that I believe today is the beginning of a dialogue that it's almost implicit for us as a university to lead. We live in a very different time, I'll tell you. I've been through a few decades of times now. This is a very, very different time. And our role as a university and our responsibility to our students is to help equip them, I hope, is to help equip them to deal with the challenges that are here today, and again, in my estimation, will escalate, as we go forward, Unity, not divisiveness. Thank you.
Thank you, President Berkman. Thank you, everybody. Thank you, President Berkman. Thank you, Provost Zhu, and a special thanks, of course, to Vice President Maurice Stinnett, who has led this effort and is responsible for this excellent forum today. And this is one of those times when the audience is as distinguished as the panel. So we want to thank all of you for being here. I do take the prerogative of the monitor to point out one person in the audience, who is my wife. She also happens to be the president and CEO of the Diversity Center of Northeast Ohio, and I'm hoping to get a standing ovation at home if you give her a standing, no, just right. As long as you give her an ovation now. Peggy Zone Fisher right here, okay. Okay, maybe I won't get a standing ovation, but whatever, okay. We have a very distinguished panel today. Somebody who I've known for a long time, one of the great judges in our county, Judge Cassandra Collier Williams of the Cuyahoga County Court of Common Pleas. We have Professor Kevin O'Neill, who is not just an Ohio expert, but a national expert on the First Amendment and teaches a class on the First Amendment that is sold out every year to capacity because it's probably the single most popular course in our law school at Cleveland Marshall College of Law. And in a few minutes, we'll have a video conference in a third panelist, Kylie Gall, an attorney in private practice in California, and she'll be introducing herself. I'm going to just tell you a brief story, and then I'm going to ask Professor O'Neill to give us a little background on the First Amendment as context for our discussion. The story that I'm going to tell you goes back to 1984. I was an Ohio State Senator, and there were a series of cross burnings on the front lawns of some African American families in the Collinwood area that I represented. The Collinwood area actually was represented by two state senators. The other state senator was Mike White, who later became the mayor of Cleveland. And when this occurred, Mike and I immediately got together and wrote a draft press release, and we were going to do a press conference. And I said, you know, Mike, this is what we always do. We always do a press release, to do a press conference. Why don't we write a law? He said, okay, what do you want? He said, well, I'm going to call the ADL. And Anita Gray knows this story because she's here today from the ADL. And I contacted the state director of the Anti-Defamation League, and I said, we want to write a law that says that if you commit a crime against someone else because of their race, their color, their religion, their ethnic origin, that's just not a crime against that person. It's not even just a crime against the community. It's a crime against society and deserves stiffer punishment. It became known as Ohio's ethnic intimidation law and later became known as Ohio's hate crime law, and I was privileged to be the chief author and sponsor of that law. But little did I know that 6 years later, when I was elected Attorney General of Ohio, I would have this unique opportunity to defend the very law that I had written. Because the ACLU, one of the most respected organizations in the world, challenged that law, saying that it was really a violation of the First Amendment because we were punishing hate speech, not hate acts. The chief legal director, the chief legal officer of the ACLU at that time was Professor Kevin O'Neill. He sued me, and we went up against each other in an argument before the Ohio Supreme Court. And I was nervous for many reasons, not the least of which I was going up against a national First Amendment expert. Now, I want you to know that I thought I gave a brilliant argument. And he did too. But the bottom line is that the Supreme Court ruled the law that I had written unconstitutional. And Kevin O'Neill won the argument. But he won the battle. He did not win the war. Because not so long after, a similar statute in Wisconsin went up to the U.S. Supreme Court, and in the landmark case of Wisconsin versus Mitchell, it declared a statute almost the same, virtually the same, as Ohio's constitutional. The Supreme Court reversed its decision. I won, Kevin lost. So that brings us now to the First Amendment expert, and I'm going to ask Professor Kevin O'Neill to give you a little background on the First Amendment. Professor?
And to this day, I'm still carrying Dean Fisher's briefcase. So that's my principal job at the law school, is to carry his briefcase. So I thought that I would just try to spend 6 or 7 minutes giving you some background, basic First Amendment background, so that we all have it, and it may be helpful to our discussion. So I made a short PowerPoint presentation. Here's the text of the First Amendment. Congress shall make no law abridging the freedom of speech. Now, notice that phrasing. This comes from 1791. That's when it was ratified. Notice the phrasing. It's negative, right? And it is a restriction on governmental power to regulate speech. Okay, so, and it was a limitation just on the federal government, but in 1925, the U.S. Supreme Court ruled that the First Amendment reaches other governments than the federal government. It also reaches state and local governments via the Due Process Clause of the 14th Amendment, which does apply directly to state and local governments. So ever since 1925, the First Amendment has applied to not just the federal government, but to state and local governments as well. Now, that means then, let's see if I can get this to advance. There we go. So that means then that when you're looking at a possible First Amendment problem, you have to be looking for what lawyers call state action. You're looking for some governmental restriction on speech. If you don't have state action, you don't have a First Amendment issue at all. So let's say that I go to work for a private company, let's say Progressive Insurance. And let's say that in my cubicle at Progressive Insurance, I want to put up a big poster of Che Guevara, all right? And let's say that my boss at Progressive Insurance says, O'Neill, you're going to take down that poster of Che Guevara. We want no revolutionaries showing their faces here in the hallways of Progressive Insurance. Has my First Amendment right been violated? Absolutely not, because Progressive Insurance is a private organization. There is no state action, and hence the First Amendment doesn't apply. So the first important thing to remember about the First Amendment is that it serves only as a restriction on governmental regulation of speech. Now, of course, a public university like Cleveland State University is a governmental actor, so the First Amendment does reach us in ways that it would not reach a place like Case Western Reserve, which is a purely private entity. I guess my thumb isn't fat enough for this job here, but the rest of me certainly is. There's no question about that. Okay. All right. So you have to press it 78 times. That's what. All right. So under the First Amendment, the government is denied one power, but it's a very important power. The government is denied the power to pick and choose which viewpoints may be expressed. Now, how did that happen? Well, it happened because of our turbulent history. Let me just, 78 times, there we go. Our history is replete with many, many efforts by the government to criminalize, to outlaw various viewpoints. And let's go back to 8 years after the First Amendment was ratified. In 1798, Congress passes a law called the Sedition Act, which made it a crime to criticize the president. Now, you know, if that were the law now, all of our late-night talk show hosts would be on death row, right? So specifically, it was a law that criminalized criticizing the president or Congress. So what happened to the First Amendment? Well, I guess Congress wasn't taking it very seriously, although this is regarded as sort of an unhappy passage in our history. Basically, the First Amendment meant almost nothing for the first 140 years of our country. It wasn't until the middle of the 20th century when the Supreme Court began in any meaningful way to enforce the First Amendment. Nobody won a First Amendment case in the U.S. Supreme Court until the year 1932. So we have the Sedition Act. Next, we have ferocious punishments for anti-slavery speech in the pre-Civil War South. If you express the opinion that slaveholders had an illegitimate interest, an illegitimate property interest in their slaves, you would face 1 year in jail in some states. In other states, for a second offense, you would spend 21 years in hard labor. So this is what some of the southern states had as a viewpoint restriction on the wrong viewpoint at that time and place. Let's fast forward to the year 1917, and women are seeking the vote. In the cities of Boston and Washington, D.C. alone, in that year alone, 500 women were arrested and jailed for protesting in favor of the right to vote. Okay. So again, and by the way, at some of those demonstrations, American soldiers and sailors beat those women savagely while police watched. No punishment for any governmental official anywhere in sight there. Okay? Again, we're criminalizing, at that time, a hated minority viewpoint. All right? And of course, the theory of the First Amendment is that the government's not allowed to punish viewpoints so that minority viewpoints have the chance to be heard and accepted by a majority of people. And once that happens, you know, they have the protections of the ballot box. Finally, one more historical example. What about opposition to our involvement in World War I? The federal government took very seriously any opposition to our intervention in World War I. 2,000 separate individuals were criminally prosecuted by the federal government for opposing our intervention in World War I, and they received 10-year jail sentences. Among them was Eugene Debs, the leader of the Socialist Party, and at this time the Socialist Party commanded 20% of the electorate in New York. So it was a minority party, but it was a substantial minority. Anyway, he gives a speech in Canton, Ohio, where he's speaking to draft-age men, and the most provocative thing he says in that speech is that you are fit for something better than cannon fodder. He is arrested, jailed, prosecuted in the old federal courthouse in Public Square, right here in Cleveland. He's given a 10-year jail sentence, and in the year 1919, the U.S. Supreme Court upholds that conviction and that jail sentence. So this is why the government now is not allowed to pick and choose which viewpoints may be expressed, because the government has shown a willingness throughout the history of our country to pick and choose unpopular viewpoints for special prohibition and punishment. Now, it's important to understand that although the government has to regulate hate speech in a way that conforms with the First Amendment, there is no requirement that the government embrace hate speech. There is no requirement that the government say, oh, you know, those fascists, they do have a good point. That's not necessary. There is a distinction between the legal protections for hate speech and the appropriate moral condemnation of hateful speech. And the government is perfectly allowed to express condemnation of hateful speech. So there is a difference here between the legal requirements and the government's ability to condemn what it thinks is immoral and wrong. Now, not all speech is protected. The Supreme Court has carved out some categories of unprotected speech. On the left-hand side of the chart, you see the 5 completely unprotected speech categories. If speech falls into the narrow definition of any of those 1 categories, it is completely unprotected. The government can ban it. The government can criminalize it. Over on the right-hand side are 3 categories of speech that are less than fully protected. For example, defamatory statements, which are false statements of fact that injure a person's reputation. Commercial speech, which is commercial advertising. As we know, the government is allowed to regulate advertising to prevent false or misleading advertising. But what I think all of us are probably more interested in are the 5 categories over on the left-hand side. And we can talk more about those later if anybody wants to. But they are the advocacy of imminent lawless action. This is exhorting others to commit a violent crime now or in the immediate future. 2, obscenity. No reason to go into that right now. Child pornography, another. And then fighting words and truth threats. Those are completely unprotected as well. We can talk more about those later. Now, one last thing, and I'm sorry if I may have spoken more than my 7-minute allotment here. You should be aware that the Supreme Court in the early to mid-1990s made it extremely difficult for governments to prohibit hate speech in a series of decisions. I think the 3 most important ones are listed up here. You have RAV versus City of St. Paul, which struck down a hate crime statute. The court did uphold in Wisconsin versus Mitchell precisely the kind of law that Dean Fisher advocated. So what we're talking about here is hate speech, not crimes where you're selecting your victim based on a bigoted viewpoint. That's what the court upheld in Wisconsin versus Mitchell. But in RAV, the court made it almost impossible to enact a hate speech provision in an ordinance. Also, college hate speech codes were struck down all over the country in the late 80s and early 90s. Let me try to explain why in 30 seconds. If the government is going to ban speech, it needs to find one or more unprotected speech categories and to ban the speech that is within those unprotected speech categories. As long as the government regulates speech within one or more of the unprotected speech categories, the government is on firm ground. The problem is that in order to punish a lot of hateful speech, speech that is deeply, deeply felt by various people in society, the government often has to enact a hate speech prohibition that goes beyond these narrow definitions of these unprotected speech categories. And so these laws all got struck down on overbreadth grounds. So that's basically the background. I've already spoken too long, and I apologize.
Professor O'Neill, that was extremely helpful. I'm going to ask a few questions to both of you, but I'm going to ask the judge to begin the conversation, Judge Cassandra Collier-Williams. And here are the questions I'm going to ask you both to answer. We all know that the primary reason that we are here today is because of a hateful incident that occurred with a flyer that, in a sense, as I understood it, was urging members of the LGBTQ community to commit suicide. And I just heard Professor O'Neill say that unprotected speech includes imminent lawless action, fighting words, true threats. My question is that unprotected speech or is it not? And help us understand that particular incident that recently affected all of us within the framework of the First Amendment. Judge, and then Professor O'Neill.
Thank you. And again, thank you for inviting me to this panel. The type of speech that we're here about when you are looking at the flyer and what it indicated to the LGBT group, it really has like a balancing there, because the easy answer is it's protected speech. Simple as that. It's protected. And it's protected because it was a posting that was within the guidelines, I'm assuming, of the university, even though I think that they did not get proper permission before they put it up. But if the university allows groups to put up postings, then that would be okay. Now, the interesting quirk to this is that if you interpret it as encouraging a violent act and the act of committing suicide, well, then you're getting into the area where it may not be protected, but then it boils down to a case by case and an issue of interpretation for a court to look at. I don't think that on its face is clear as to what exactly it would mean to any given person. So in that instance, or the instance what we're here for today, it really, we really have to look at it to, okay, we really have to see if, on a case-by-case basis. So I saw part of the poster, but apparently there was something at the bottom that apparently I didn't see that was cut off, maybe that said you should do it or something like this. I'm not sure what it said. But depending upon what the words are, they could be interpreted. And again, if that same poster, for example, was posted on someone's door, then that could be a direct threat, and that would be actionable. But if it was posted around on poles or on a student board or things of that nature, that would be something that's on a case-by-case basis. And you may take it to court, and the court may deem, based upon all the facts, that it is not a threat, and therefore it would be protected speech.
Before Professor O'Neill speaks, I do want to acknowledge that Kylie Gall, an attorney in private practice in LA, is joining us. Although I noticed just a second ago that the screen is a little different than it was 2 minutes ago, but I'm sure, are you still with us, Kylie?
Yeah, I'm still with you. Can you see my screen?
I can hear you, and for a while there we could see you, and we're going to keep working on. Now I can see you, Kylie. We're going to have Professor O'Neill answer that question, and then I'm going to go back to you. Is that all right?
Sure, that's no problem.
Great, thanks, Kylie. Okay, Professor O'Neill.
Well, I'll keep this very brief because we have not heard from Ms. Gall, so you've already heard more than enough from me. I think what a First Amendment lawyer would do is to go through the categories of unprotected speech, and I think that of them, and by the way, I completely endorse everything that the judge said. I think of them, the true threats unprotected speech category is the one that I find most intriguing. If you look at the lower courts that have interpreted the true threats category, they say that the courts are required to consider all of the surrounding facts, which means that you wouldn't just look at the four corners of the poster. Now, the judge mentioned that she hadn't seen the full poster. The full poster has at its top, and please pardon my language when I'm just quoting it, it says, "Follow your fellow faggots," and then it has the suicide statistics. So you could read that as an exhortation to commit suicide. But I think that if you look at the way the body, there's a person who's hanging, you'll notice that the hands seem to be behind the back. And if you're going to commit suicide, I don't know about you, but I'm going to need the use of both hands to hang myself. And what's interesting about the poster is that the hands are not dangling down in front, they are behind. That's a lynching pose. That's what that is. And so the suggestion would be, and then the timing. The timing is right when the LGBTQ Center opens. So looking at the full, I still think this is a weak argument and many judges would reject it, but there's at least a possibility that a judge would say, I'm going to let this go to a jury, because if you look at the full factual context, if you have the LGBTQ plus center opening right when the poster materializes, part of what they seem to be saying is, if we catch any of you going into that center, we're going to come after you. And that would be, in that context, a threat. Take that poster and have, one of these rotten fascists holding it at Public Square on broad daylight, I don't think it has the same, it's not in the same context. You remove it, you put it in a traditional public forum, and I think you have a much harder time saying it's a threat. But post it on the campus right when that center opens, I think you can make an argument. It's a tough argument. Many judges would reject the argument. But I think that if you want to try to find an unprotected speech category for that poster in that context, I think it's true threats.
I should mention that Phyllis Harris, the director of the LGBTQ Center, is here today, as Anita Gray is of the Anti-Defamation League. Alana Jochum could not be here today, but she's been very involved in this effort. She's a graduate of Cleveland Marshall and the director of Equality Ohio. And I would be remiss if I also didn't acknowledge the excellent behind-the-scenes work of Sonali Bustamante Wilson, who's the general counsel of CSU. Now we're going to go to our special guest, Kylie Gall, who is an attorney in private practice in California. Kylie, if you could do me a favor, if you could first tell us a little about you and then your views on this subject. Please go ahead.
Yeah, let me give you a little bit. As far as my background, I'm actually an attorney in Ohio and Oregon. And I'm in Portland at the moment, and I spend a fair amount of time working with young people in the LGBT community who either can't afford or don't have access to legal services. And I spend a lot of time getting their viewpoint and trying to help them through issues. And I guess it's just as a quick onset, the poster at issue is widely known to young people in Oregon. It's kind of an internet, trending thing. So, the views I share are my personal views and viewpoints that I have, I guess my own personal views as a member of the LGBT community and viewpoints that I've heard in dealing with young people who have been exposed to the flyer. A lot of concern, I think I would say, I agree with the analysis from the professor, from Judge Collier Williams. The question really is whether or not there's a true threat there. I think the pejorative slogan at the top of the poster and, what clearly appears to be a lynching poster rather than a suicide poster is informative. The other comment that I had a lot of people make when we talked about this was the bottom of the poster, which I don't know if it's shown in all the versions, but I think it says something to the effect of fascist solutions. And to identify someone as a fascist is a dictionary definition of that is to promote unlimited government power, unconstrained. And we're talking in the context of the First Amendment here, which is, by its very definition, a restraint on the federal government, and in this case, the state government as well, through the Due Process Clause. So I think a lot of the, whether or not there's a true threat there has to be considered in light of what's the real message that's being said by the poster, who is the target group, and will that threat adequately reach it, especially when you consider that the LGBT community has been targeted in that way, especially trans people. There's a slogan related directly to trans people at the top of the flyer, and violence against trans people, especially trans women of color, is very common. And then the bottom of the flyer, with a fascist solutions, what is the solution that's being advocated? It sounds like it's either a direction to suicide or it's suggesting a lynching. Again, the question is whether or not there's a true threat, that would take this out of protected speech. But I can tell you, in talking to community members, this is received as a threat to them, at least on a subjective level. I mean, people feel like this is definitely targeted, and the way in which it's posted, I think, could be a part of that threat too. I've seen some pictures where it was posted with another sheet over it, suggesting one thing or another. So just to give you a little perspective from that, and I'm glad to answer any questions regarding kind of at least the community members who I've talked to and their opinions on it.
Thank you very much, Kylie. We'll be back to you in a minute. The next question I have for the three of you is that if you were in the administration of Cleveland State University and wanted to revise the current policies with regard to posting such a flyer, is there a way you might write that policy that might not allow someone with this particular poster to post it? Or is that not advisable to begin with? And I'll begin with Professor O'Neill and then go to the judge and then go to Kylie.
Well, I think now we're talking about a different body of First Amendment law that I didn't review for you, but it's called the Public Forum Doctrine. Public Forum Doctrine deals with any use of government property as a platform for expression. And to the extent that this is a campus of a public university, the bulletin boards that are scattered throughout the buildings may, not, well, they're certainly not traditional public forums where there's the greatest right of access. They may well be non-public forums. I'm not being clear. In the public forum doctrine arena, what the Supreme Court does is to try to figure out how to categorize the government property to which the speaker seeks access. And there are 4 different categories, and depending upon the category, the rules change, and there's greater or lesser protection. Traditional public forums are public sidewalks, public squares, public parks, public streets. This is not a traditional public forum. Then there's designated, limited, and non-public forums. With a non-public forum, there's no right of expressive access whatsoever. With limited and designated public forums, they are created only where the government affirmatively dedicates the space for expressive purposes. Now, I don't know if those were departmental bulletin boards, which might properly be regarded as a limited or non-public forum, but that's, I think, the analysis that you would go through. You'd ask yourself, how do we categorize the bulletin board? It could very well be a non-public forum. Remember, this whole building is a non-public forum. My classroom is a non-public forum. The entire law school is a non-public forum. And in non-public forums, the government does not have to afford any expressive access whatsoever. And with a limited public forum, it's only where the government has expressly dedicated the property to some limited expressive purpose. And the government can limit it to that purpose. So I think that this is probably the right First Amendment doctrine to be looking at when you're looking at the display of this poster on a bulletin board on a public university's campus.
Judge?
Yeah, and just piggybacking on what he's saying here, if you're going to limit the bulletin board, then it's limited across the board. So if you say, I don't want this type of speech, so now I don't want any type of speech up on these bulletin boards, that's for everything, and for everything, then it's all gone. If you say, well, we want to let some of it in, but we want to keep out the hateful speech, that's where the problem arises. So I think it boils down to either you allow it and you allow it all across the board, or you say there's going to be none of it. And so it's none across the board. Because when you begin to pick and choose, there's a quote that I had here from one case that I was looking at. And this is from a Supreme Court case that came out regarding free speech. And it was talking about one of the, Justice Alito indicated, and I quote, "The proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate." So if you are standing up on the First Amendment, and if you understand that that right applies to everyone, then you really can't limit the access to the bulletin boards unless you say you limit it across the board. So in agreement with what he says, like you said, the law school is, you can't just go in there, it's non-public. And that may be something that the school as a whole want to embrace. But if you don't do that, then you are looking at allowing it from everybody with all types of thoughts as well, as long as they don't hit those categories that we indicated are not allowed.
Kylie, are you still with us?
Yeah, still with you.
Hey,
You
did
may
you
not
hear
have
my
my video,
question?
but with you by audio.
Did you hear my question?
Obviously, I agree. To the extent you're going to make a restriction, it has to be applied across the board. I think we would just want to be clear that, categories about threats or imminent violence or imminent unlawful activity are going to be prohibited across the board. No organization will have a chance to do that. I don't know that it's not clear to me whether this posting was on a public bulletin board or whether it was reserved for a different purpose. But to the extent you had a permitting system or you had a restriction on who could post something, obviously that needs to be uniform.
We have only 10 minutes left according to my agenda, and am I allowed to open it up to questions from the audience? Great, I'd like to do that. So we have some microphones on both sides. All you have to do is raise your hand, and I ask you if you are comfortable to identify who you are. If you're not comfortable, you don't have to. Okay, let's go over here first.
Hi, my name's Emily. I just want to get a better understanding of exactly what our poster hanging policy is.
I think that it's fair to say that none of us on this panel can answer that question authoritatively, but is there somebody here who's comfortable doing so? Sonali, you want to come up here and use this mic or use that mic? Okay, this is Sonali Bustamante Wilson, General Counsel, Chief Legal Counsel, you know what I'm doing, of Cleveland State University.
Okay.
Yeah, the question was, what does the current policy say that affected this particular poster?
Okay, the posters were, to my understanding, on bulletin boards that are run by our facilities, our conference services. And in order for a poster to be on those particular bulletin boards, they have to have a stamp of approval. And those posters did not have the stamp and were taken down immediately because of that. So there was no determination of content or anything. It violated the policy of pre-approval.
Sonali, if I could just ask a follow-up question. Let's assume that they had followed the approval policy. Is there anything in that policy that would have still said that it had to be taken down, or as long as if they received permission under the current policy, there was nothing the university could do and it would have to keep it up?
If it had gone, if it would have been a balancing decision, then at that point, similar to what the panelists have talked about in terms of, whether it was threatening, whether there was nothing else in the policy for those particular posters at that time. We didn't get to that because they were
Right.
taken down. But had they been properly approved, then we would have to make the decision along the lines of what the speakers were.
Sure. Professor?
I think an important distinction here, if we're talking about a limited, you see there's the designated public forum and the limited public forum. The designated public forum is a non-public forum that the government expressly opens to all speakers and all topics. That's obviously not what this was. The limited public forum is where the government takes a non-public forum and opens it up to a limited range of speakers or for a limited range of topics. For example, you could limit it to registered student organizations. Okay, and so that would be a limited public forum. Okay, and then the thing about limited public forums is the only thing the courts police for is whether viewpoint discrimination is used in deciding whether or not something gets to go up. So that's the one thing you have to watch out. So if you do open it up to a limited public forum, then you're not allowed to engage. So you couldn't say, for example, we're not going to let an LGBTQ group use this, but we will let other student groups use it. Once you say that it's open to all registered student groups, then it has to be open to all registered student groups. And there's a Supreme Court case called Whitmar versus Vincent that so holds.
Right, it's not clear. I don't know that those posters would have been approved because, as the president has noted, that approved organizations can put posters up, and typically they are limited in terms of time, place, and to announce events that are taking place as approved and through conference services. So it would be limited as to time, place, and what the purpose of the poster
So was
is.
this an approved organization of the, it's not,
Oh,
so
no.
it probably would not have been able to be approved.
Yeah, so I mean, if this was not a registered student organization, then their poster could be excluded under the doctrines of the limited public forum.
All right. We have a question over here.
Now, the idea has been going around that if this is a approved student organization, then there would be no problem posting these flyers. And my question is that do we have policies in our university that would prevent a white supremacist group from getting university funding as an official student organization?
Maybe I'll ask Professor O'Neill first to answer whether or not the university could even do that.
I don't know what the policies are. I don't think that the government can pick and choose which organizations get approval and which don't. I think that they have to have what is essentially a neutral criteria. In other words, we're going to open this up to all registered student groups, that's okay. But as the Supreme Court has said in Widmar versus Vincent, once you start just picking and choosing which student groups get to speak based on their viewpoint, now you're in trouble under the First Amendment.
Let's go to another question. Let's go to the back of the room next.
Yeah, my name is Shahad Abdul Karim. I'm Director of Facilities here on campus. Just want to clarify that postings are not allowed in any other location but bulletin boards. So any posting that's placed on any walls, doors, handrails, columns, concrete, areas of the campus, those are not allowed whether the message is good or bad. All locations that are designated for posting are usually managed by either conference services or the department that owns them. And I know that Rodolfo here can explain how student groups can put postings on those bulletin boards that are managed by conference services. So if you don't mind, I'd like to pass the mic on to him to explain.
My name is Rodolfo Paxanan. I'm the current Director of Conference Services and Events here at Cleveland State University. Thank you, Shahada, for painting me into a corner. That being said, clarity on the posting policies of the university. The facility use policy by the university, which is published online, states that the use of space and facilities here for non-academic use is determined by the president or his designee. In this case, the designee by policy is conference services. And in this case, the postings on the bulletin board, specifically the ones where the flyers were found in main classroom, that's my turf. Conference services oversees 33 general use bulletin boards from Urban all the way to Fenn Tower. Those happen to be the ones that we were responsible for. That being said, those flyers that went up were never vetted through our office. Were never brought to our office for approval for posting, because you can see if you go to the boards now, which we police on a daily basis, if there is literature on there that does not have a stamp from us, that's the guarantee that it never went through the proper procedures and were approved, were stamped by us, and set up by my staff. That being said, the overall policy, which I stated is non-academic use of space by the president's designee, my internal rules within the Office of Conference Services in determining what is approved and what isn't approved, again, the differentiation between the rules and the policy. The rules in conference services, which are signed off by me, and which I have to approve, is, does the flyer provide a service, resource, or opportunity for the internal CSU community and originates from the internal CSU community? Faculty, student, or staff? Is it faculty or a staff program, a resource that's offered to the internal CSU community? Student, is it a registered student organization through the Office of Student Life? The other thing that the internal rules, which I use to govern what is approved or not, is the CSU business? Does it benefit us? Is it a service? Is it a resource? Does it benefit us? Because if it's not, I'm not going to approve it. That being said, I use those rules and guidelines because I don't want our boards situated within our academic buildings to degenerate into a Craigslist with people advertising they need a roommate, or they're selling their 1996 Honda Accord, or that there are drink specials over at this bar over at the Flats. Because that's what we ran into a couple years ago when we decided to just say, okay, we'll accept things as long as it's not obscene or it isn't threatening or whatnot, but it started to get out of hand. So for those of you who may have been conscious or noticed in the last couple of years, the boards kind of got cleaner, there was less garbage on them, and now we police them every day, and if it doesn't have a stamp, we take them down. So again, the policy is non-academic use of space, discretion of the president or his designee, the internal rule within conference services, the director approves it under these rules, and the rules are, is this internal CSU? Is this a benefit to the internal CSU community that's provided by internal CSU?
Thank
Questions?
you. You know, even though we were scheduled to stop at 12:30, Vice President Stinnett has given me the sign that we can go a little over. So here's what we're going to do. We're going to take 2 more questions from the audience, and then I'm going to ask each panelist to make any concluding remarks. Please go ahead.
Hello, my name is Simranveer Kaur. I'm a student activist and advocate, and what my question is I would like an elaboration on what defines a threat and and a definition of a threat under unprotected speech, because many students felt that poster was a threat in terms of, if you do not kill yourself, we will, and I would like to hear more about what constitutes a threat under unprotected speech.
I anticipated this question, and so I have the text. I anticipated this question, so I have some extra slides, one that specifically deals with the elements of a true threat, of an unprotected threat. Yeah, same presentation. Okay, let's scroll down. Okay, and then can we...
Kylie, we'll be back to you soon.
Yeah.
Sure.
Tomorrow, I'm going to have this for you. That I promise. Okay. Can you kind of flip forward? Keep going. Your thumb is better than my thumb. So. Okay. Keep going. Keep going. Okay. This one. Okay. Here are the elements of a true threat as developed by the federal courts of appeals. To prove a true threat, the prosecution should have to prove, and all these 3 elements, each of them has to be satisfied. The speaker made a statement intending to frighten or intimidate the victim with a threat of harm. The speaker knowingly suggested that the threat would be carried out by the speaker or his co-conspirators, and that a reasonable person who heard the statement would conclude that it was meant to threaten the victim with harm. So that's the elements that you would have to satisfy, or that a prosecutor would have to satisfy if they were going to prosecute someone for that sign. And it's the same standard that we would use in determining whether or not it constitutes a threat. Thank you, sir.
That's very helpful. Let's go back there.
Hi, my name is Nikki Antonio.
Oh,
I'm a
State Representative Nikki Antonio.
Thank
Yes.
you. I appreciate the conversation, and my question for the panel, all of you, is that right now there is a piece of legislation that has been recently bantered about, introduced. I don't have a number for you, but they're calling it the Campus Free Speech Act. For all of you who have read 1984, you know that sometimes things are not what they appear to be. And with this act, it actually, while the name suggests that it expands free speech, it actually limits free speech, especially, my understanding is the discretion of the president, which in this case, according to what I understand, ultimately made this possible to remove these posters. Should that Free Speech Act in Ohio pass, presidents would not be allowed to exhibit their discretion. Can you say a little bit about where state law comes right up against public policy of universities? Thank you.
Let me try to have Kylie address that question. Kylie, could you hear the question? There's a piece
Yeah, referring to the pending legislation, the campus free speech bill.
Yes.
I guess I would agree with the speaker's characterization of the bill as possibly a misnomer, as an attempt to restrict the president's discretion on that. I mean, ultimately, on a personal level, I wouldn't be in favor of that legislation. But I don't think anything can cause the president to leave a threat hanging on a board. And in the case of the flyer at issue, I mean, when you strip that down, there really is no political speech in that flyer. And what some people may consider, oh, this is political speech, this should be up, we need to eliminate the discretion. Any kind of state law you would pass would not change First Amendment protections under the federal Constitution, or the lack thereof applicable to certain speech. So hate speech would still be hate speech. While I personally wouldn't support that legislation as drafted, I can't see how this would change, the president's ability to take down what he or she believed was a threat. And I think if you look at the flyer at issue, there's very little political speech in that flyer to be protected. And the statistics that are on that flyer are baseless. And when you take those out and you take out the visual element, what speech is left? That would be my comment.
I'm going to say to the judge and the professor, even if you have something to say, hold it, and I'll let you say what you want to say, plus answer the next question. So let's go to the next question, because it's the last question. Okay. Oh, here's your last question right here. Stand up.
Hi, my name is Brian. When Rodolfo was speaking earlier, he mentioned that we used to have the ability to limit posters based on their obscenity, and then we changed that policy to accepting posters based off of student organizations. Does that mean that under an older policy, a poster like this would have been denied even if it went through a student organization? Or even under that framework, would it still have been something that had to have been accepted by the university?
You said we used to have a policy, and I didn't hear the first part of it. That what?
I believe Rodolfo said, and I could be mistaken here, but we used to have a policy that would have limited posters that would have been hung up based on things like obscenity.
Okay.
So if that framework were still in place instead of what we have now, would that still have been an issue with the poster being approved through the proper channels? Or I guess basically my question is, would this have been solved if we stuck with the framework we had where we could limit what's put on posters based on obscenity or true threats?
I'm going to ask each of our panelists to try to answer your question and give a concluding statement on anything they want to say. So we'll start with the judge.
Okay, to try to answer your question, I think what you're saying is that if this poster was that this was a student organization, is that what you're saying? I didn't hear you. That this was a student organization, and that therefore, if it was approved, would this have been okay?
My understanding is that right now, even if something was put through by a student organization that was obscene, because it was through a student organization, we don't have the ability to limit it. However, previously, based off what I believe Rodolfo said, we would have been able to limit it because it was obscene or because it was a true threat.
Mm-hmm.
So would it have been protected speech in that case? Would it have been something we could have acted upon in that way, or would we still had our hands tied?
Well, I think what the person who's over those bulletin boards, I think what I heard him say was if the poster did not bring something to the university, if it did not involve something that was of benefit and not just an ad, that he would not have allowed it. Now, but the thing that caught my ear with that was he uses a lot of his discretion. And so the question becomes, if, let's say the alt-right, they started a student organization, and that organization was approved because the student organization, they said, we want to, they may say, we're not promoting hate, we just believe that America is for white people, straight, etc. And they then went to this, the place where they get the approval for the bulletin boards and say, I'm going to put up a sign that just says we have an organizational meeting and we want people to come. So the organizational meeting, I want to post a sign. Now, even though he may say, I don't want that, you guys, you spew hate, it may cause issues, I'm not going to approve it, but I think that you almost have to approve it because it's a student organization and they're talking about, they are trying to, well, let me put it this way. There's really nothing in the flyer that would be hateful or anything like that. So whenever you say that someone has a discretion and there's no real rules that are laid down, that discretion, as long as those rules are applied across the board, then you're okay. But if you say, if a I don't know, a new fraternity, I'm going to create a new fraternity and, I want to put up a flyer to get members, and you say that one's okay, then you may not be able to say that an alt-right would not be okay to have that poster to go up for a informational meeting. Now, that's how I look at it, because I think, again, the bottom line is you have to treat everybody the same. So if you say the bulletin boards are only for, I don't know, classwork, then fine. That means whatever somebody else comes up and they say, I want to put up a bulletin board talking about a meeting. Sorry, no meeting. It's only for classwork. It's only for class-involved things. But if you say, yeah, it's okay on some of these, but I don't like this organization, so I'm not going to let you do it, that's when you'll start having the problems. And that's my last.
I'm going to go to Kylie next because every second goes by, I'm always worried we're going to lose that connection. So Kylie, answer that question and make any concluding statement you'd like.
Yeah, I would agree with the judge's comments that to the extent that you're going to allow a student group to post flyers, any student group can post those flyers. That said, no student group can post a threatening flyer. And if whatever the standard is for determining a threat, that has to be applied to all groups. So, for example, if an LGBT group said, hey, we got to protect ourselves, we need to strike back, and suggested violence or unlawful activity, that itself would be prohibited. The standard has to be applied equally. To the extent the question is directed to the president's discretion, the president just has to do his best job in determining whether or not he thinks there's a threat under these circumstances. I think just to sum it all up with a final point, I would say when looking at something like this and considering the threat, I think it's just important to boil down a sign to its true message and, what's really being said. The First Amendment is interested in political speech first and foremost. And when you look at a sign and you see that there's very little political speech there, if any, in most cases, that item is not entitled to protection.
Thank you, Kylie. Let's have concluding remarks by Professor Kevin O'Neill.
Okay, back to your question, sir. You posited the idea that if a speech were obscene or a true threat, it might still somehow be protected. That's not true. If speech falls within one of the unprotected speech categories, it is completely unprotected. It may be banned, it may be censored, it may be criminalized. And there's no obligation on the part of any governmental official to allow speech that falls into one of those categories. I think an easier way to deal with this problem is not to get into content, but to go back to the public forum doctrine and say, look, there's no requirement that the government open these bulletin boards for speech. There's no requirement at all. Those bulletin boards can be non-public forums. And by the way, if you want to limit it further, you can recreate as a limited public forum those bulletin boards and say they're only for upcoming events on campus. End of story. And then as the judge says, once you have created that limited category, then the government has to abide by that limited category. And it can't say, oh, well, we don't like this upcoming event, so, we're not going to allow this poster. So, but you can define your limited forum very narrowly. Also, you don't have to open it up at all. And I just published a book chapter on all this public forum stuff, and I had to research last summer to make sure I was up to date. The case law is very clear that there's no requirement to keep open a limited or designated public forum, that it doesn't have to be kept open indefinitely, that it can be shut down, and the case law is unbelievably deferential to governmental decisions to close what had been a designated or limited public forum. So to me, from an administrative standpoint, that's the way to deal with this. Don't get into content. Whatever you do, don't get into viewpoint, because the one power that is denied the government under the First Amendment is to pick and choose which viewpoints get to be expressed. And we can disagree with that, but I showed you the history, and that's where it comes from. I've been speaking too much, and I apologize. I hope that people have found this helpful.
We encourage you to apply to Cleveland Marshall College Law and take his class. And with that, please join me in thanking these three outstanding panelists.
Okay. Again, thank you all for being here. We're going to get right into this. I'm so thankful that Kylie has agreed to stay on, so I believe she can hear me. Can you still hear me?
Yeah, still
Okay,
here.
perfect, perfect. Thank you for staying on. And now we're just going to jump into the political scientist panel, as we said, to get these various perspectives. So grateful for this distinguished panel. As you already know, we're going to have Reverend Leah Lewis, talk to us, Professor Charles, Juan, and Professor Reginald. And they're all going to introduce themselves, tell you a little bit about their background, and basically give kind of their synopsis of what they've heard and from their perspective to kind of broaden this conversation and open it up, okay? And then after they each have an opportunity to speak and share with you their thoughts about what we're talking about, we're going to jump right into question and answer session from the audience. So we'll start right here with Professor Charles.
Hello? Is this microphone on? Everything cool? Okay. Is it on now? Doesn't seem to be on.
Testing 1, 2, testing.
Okay, I'm very close. Close relationship with the microphone. Okay, I'm Charles Hirsch. I'm chair of the political science department. Just a little bit about myself. I teach political theory and I teach constitutional law to undergraduates. So I've been told I have 2 to 5 minutes, which is cruel for an academic, but I will try to limit myself. So I'm just going to say a little bit about some of the legal stuff, but maybe mostly try to concentrate on more theoretical thoughts about hate speech. And because I think that hate speech can be regulated and limited, consistent with the First Amendment. I also think allowing hate speech would contradict the university's own anti-harassment policy. And I think it's also allowing hate speech is inconsistent with the idea of a university as a place for the exchanging of ideas. So a little bit about, we heard, I think rightfully so, a great ode to freedom of speech and the First Amendment. I'd suggest you could say that hate speech has little to do with actual speech, the so-called marketplace of ideas, right? I don't know what time it is. The so-called marketplace of ideas is the classic First Amendment justification for free speech. Oh, if we shut down a particular viewpoint, then it won't be allowed to be heard. The truth will not come out. I think you could argue that hate speech is not really an idea per se. That this poster that we saw, urging gays and lesbians to kill themselves, or even urging lynching, really has nothing to do with the wonderful litany of great speech acts that we heard about in the past, of women's rights, of the civil rights movement, and so on, that Professor O'Neill talked about. I just don't think it belongs in that list. And there's a case I do want to mention that actually speaks to this, called Christian Legal Society versus Martinez. And this was a case where Hastings Law School had a regulation that any student organization could not discriminate basically on the basis of race, sexual orientation, and so on. They argue like, oh, well, this Christian Legal Society wanted to exclude gays and lesbians. And they said, oh, if you don't allow us to exclude these people, then that's violating our free speech rights, our freedom of association, and so on. And the Supreme Court said, no, you can actually, they can require groups, student groups, to allow all members, to allow gays and lesbians in particular. They said it was a limited public forum, and that as long as regulations were reasonable and viewpoint neutral, that they were consistent with the First Amendment. And they said that, you know, allowing, that requiring groups to admit gays and lesbians was in the interest of allowing all students to be represented on campus and to have the same access to all organizations as anyone else. And so, you know, this was this limited public forum analysis, but nevertheless, I think it lends support to the idea that you can be consistent with the First Amendment and not allow hate speech and require anti-discrimination. So the second thing I want to say is that allowing such posters as was put up is inconsistent with the university's own anti-harassment policy, which says the following: conduct that, quote, denigrates, insults, ridicules, disparages, or stereotypes an individual or an individual's conduct, family, friends, habits, or lifestyle is prohibited on campus. It also describes sexual harassment as activity that creates an intimidating, offensive, or hostile environment for that individual's employment, education, or participation in university activities. So in a way, the question is not, should we allow this, but you could say that actually allowing it violates other university policies of anti-harassment. And then the final thing I'll say is just that you know, the idea of a university is centered around the exchange of ideas, and that that requires people to be able to feel free and comfortable and safe in that environment. And if you have posters up, such as we had, they would interfere with the university's central mission, which is to allow a place where students feel comfortable to express themselves, to be themselves, free of harassment and violence. And so that's the way I'd argue it.
Muy buenas tardes. Le quería dar las gracias al doctor Beckman por este esfuerzo esta tarde. Muchas gracias. The reason I started in Spanish is not just to show my linguistic ability, although that's part of it. The reality is this, though, that in our community, there are 22 different Latino ethnicities. Out of those 22 ethnicities, only one are U.S. citizens by birth, Puerto Ricans. So the question I pose is the following. Is English the official language of the United States? It is not. Therefore, when me and my homies are speaking Spanish and someone steps up and says, speak American or go back home, how should I interpret that? How do I frame that discussion in a way that is relevant to our reality in America? So based on what I've heard here this morning from the panel that preceded us, clearly we could interpret that as a true threat. Speak American or go home. And we're U.S. citizens, question one. Question two, does the Constitution apply only to U.S. citizens? Yes? No? No. So therefore, my colleagues from different Latino nations are also protected under the First Amendment. So I just wanted to put that out there within the context of the Latino reality, not just in Cleveland, in terms of how it is that we try to address these things. That's one. The other piece is that about a decade ago, there was an institution to the west of us that was faced with a very similar situation on its campus. The poster at that time was a depiction of what they felt Jesus Christ looked like. And it made an assumption, it made a connection between Jesus Christ, the figure, the image, and homosexuality. In other words, what they were saying was Jesus was gay. Dr. Beckman, I want to commend you and your staff for taking this issue on and giving it the kind of support and resources to address it in a meaningful way that creates effective policy for all peoples. In the example that I just shared with you, they did not do that. The example that I just shared with you, what they ended up doing was taking the posters down, not addressing the issue of the First Amendment rights of all groups that were concerned with it. The main focus was a very Christian, right-wing, conservative approach to how dare they depict Jesus Christ as a homosexual. So congratulations to you, sir, for taking this on and giving it the merit that it deserves to address it in a way that it won't repeat itself in this way. Last thing I want to say is you all are aware of the hurricane that recently hit my homeland. And the reason this is important is because for the previous 10 years, 11, 12 years or so, the economy of Puerto Rico has been devastated, even before the hurricane, because of the $70 billion debt. In that discussion about how is it that we address these issues within with American citizens, because of 1917, the Jones Act, when Puerto Rico became part of the United States, was, well, we'll make them a state. We'll make Puerto Rico, which is the oldest colony in the Western Hemisphere, a state. And that will help to resolve the financial problems that are occurring. There's folks on both sides of the issue, and here's where I come back to language. The more conservative-leaning folks in Puerto Rico and Puerto Ricans on the mainland feel that becoming the 51st state is a panacea to all of its problems. And let's go with that argument for a moment. All of those arguments will align themselves with sort of this view that everything is groovy in America, until you get to the issue of an official language. Until you get to the issue of when it comes time to acculturate 3 million more people that their first language is not English, then you begin to grasp a sense of the enormity of the language issue as it pertains to the statehood and as it pertains to the interpretation of the Constitution and the First Amendment. So that's what I wanted to share. Thank you very much.
Good afternoon. My name is Leah Lewis. I'm actually Reverend Leah Lewis. I'm a former councilwoman in the village of Highland Hills. I'm a professor, an adjunct professor at Tri-C in religion. I am a graduate of Howard University School of Law, and I also have a degree from Yale Divinity School. So let me first address what might be an elephant in the room. Because I'm clergy, what might her position be on issues pertaining to the LGBT community? I support same-sex marriage. I support the right of consenting adults to select their partners with respect to their sexuality. I support the human dignity of every member of our species. So let me just lay that out so there's no confusion. I also want to say that I second every single thing that Professor Hirsch has said, because I agree with every point he has made. I too have read your policy against discrimination, harassment, sexual violence, and retaliation. But I've also read your policy on, it's called expressive activity policy. And there is a line in there that needs resolution. It appears in the second paragraph, and it says that college employees will not consider the content of expressive activities when enforcing this policy. That is it's directly a problem with respect to your harassment policy. With regard to the poster, I have not seen it, but I'm very grateful to Attorney Gall for her expression of it. My position, and let me admit I'm a lefty, is that it was hate speech, that it was inciting violence, that there is no doubt about that from my perspective. I also find it interesting that people say, well, what if this poster had been sent before institutional authorities for an assessment? It wasn't sent because the person who placed the posters knew that it would not be approved. They sought to circumvent the system. Now that you know this, and you know that there is an individual or entities out there circumventing the process, they need to be held accountable. They can be called in because of the circumvention of that process. And let me go further. As someone who has written her dissertation on sex and sexuality in the African American Baptist Church, I contend that whoever posted these posters is dangerous and quite possibly a sociopath. Why? Because they sought to break the bonds in this community. They need to be addressed in some manner, whether it is simply a conversation with key individuals in the administration, or whether you need to call in someone who can counsel and mediate them. Now, I also believe that the position that was articulated on the poster is indicative of a cry for help and attention. I think it is a person who has been socialized in a particular way, and that way really speaks to fear, ignorance, and oppression. Thank you for your time.
My name is Reginald O, and I'm a professor at the law school here. And I actually was supposed to be on the first panel, but I had a class right up to this, so that's why I'm on the second panel. So I'm going to talk a bit about some of the legal issues. I know you talked a lot about true threats on the first panel. I just would want to quickly add that there's a case called Virginia versus Black, which I don't think came up, in which the court held cross-burning was a criminal statute that prohibited cross-burning was constitutional if the cross-burning was done with the intent to intimidate. And so I think it's better to think about the speech, the flyer, as more about intimidation rather than threat. And with intimidation, they define intimidation as intimidating to and trying to put someone create a fear of violence or bodily harm, or feeling scared about their personal safety. And I think arguably the flyer did that. And if that's so, then it is unprotected speech. And so it's I think a lot like cross-burning, okay? And the important thing, and the speech doesn't have to be targeted at a specific person in order to be intimidating. It could be directed towards a group of people, okay? There's a California statute which uses the word terrorizing, that you cannot terrorize people using cross-burning, other kinds of symbols. So those are, I think, if you're going to formulate some sort of policy to deal with this kind of conduct or speech, you could think of it in terms of that language and the case Virginia versus Black. What I want to talk about, secondly, is the concept or the law regarding hostile educational environments. So there are First Amendment concerns about protecting speech, but there are also concerns, legal concerns, about ensuring that there is no hostile educational environment, either on the basis of race or gender. These are civil rights statutes. Title VI deals with racially hostile educational environments. Title IX deals with sexual harassment, but both deal with a hostile educational environment existing when there's severe or pervasive harassment interfering with the ability of a student to participate or benefit from the educational program. And the important thing about a hostile educational environment is that a hostile educational environment is created via speech. Speech that normally would be protected by the First Amendment actually is the basis for the creation of a hostile educational environment. So there are cases in which students were subject to the N-word at a school, and that was used to show that there was a hostile educational environment. There's a case involving the University of California, San Diego, just a few years ago, where there was a noose hung up on the campus. There was a KKK mask that was also hung up, which clearly is speech, but that was the basis for saying there was a hostile educational environment. And the important part about this is that the speech has to be severe or pervasive. It's important to say it's severe or pervasive. It doesn't necessarily have to be both. Something that is one time, it happens once, but it's extremely severe, like say a noose being hung up, could constitute a hostile educational environment if you keep that up, right? If you don't take it down. And if a school knows about a hostile educational environment but does nothing about it, then it could be liable under Title VI and Title IX. And with the flyer, the hard part is whether or not you can take proactive steps to take something down before, to prevent the creation of a hostile educational environment. But at the very least, if you know that a hostile educational environment exists, the school can be liable if they do nothing about it. So in the if there's a school policy where you allow the flyers to be put up and stay there, that could be knowledge of a hostile educational environment, and you might be subject to liability under Title VI and Title IX. And there's one last thought about, there's another doctrine of First Amendment called substantial disruption doctrine, which states on college campuses and schools, speech that substantially disrupts and interferes with the learning and mission of the school can be prohibited. And this includes speech that otherwise would be constitutional and protected by the First Amendment. There's a case called West versus Derby, in which this was in middle school, but a student drew a Confederate flag on a piece of paper in math class, and that was found to, they punished the students for that, and the court found that that speech would cause substantial disruption, and that was upheld. That punishment was upheld against that student for drawing that Confederate flag. So there are ways, even under the First Amendment, where you can deal with this kind of speech. So I'll just end there, and if you have any further questions.
Thank you. Kylie, do you have any thoughts from what you've heard before we go to the audience for some questions? Do you have any other thoughts?
Yeah, I had a thought for the panel, perhaps about. I think there was a comment earlier from the audience about whether or not the school would have to recognize a hateful student group or a white supremacist student group, and could that group post flyers? I think my position, at least, would be that a group that is set up in opposition to the Constitution and the rights guaranteed under the Constitution, including the 14th Amendment, wouldn't be a valid student group necessarily. For example, a student group that advocated, overthrow of the Constitution or the federal government wouldn't be entitled to recognition. I wondered if the panelists would agree that, a student group set up to oppose constitutional rights wouldn't be an approved student group.
I think you could prohibit such a group under because I think being a student group, like this case that I cited earlier, is considered a limited public forum. You don't have an absolute right to form a student group. And I would think you could make a law that would be reasonable and viewpoint neutral in the sense, or at least content-based neutral, that would say, any group that advocates violence or advocates the exclusion or advocates discrimination cannot be a registered student organization, in particular because it violates some of the other university policies. So I guess I agree with you that I think one could legally and certainly morally exclude such a group.
Anyone else from the panel want to respond to that? Okay. So now let's take some questions from the audience. As you notice, this panel is very diverse. That was intentional. We want to broaden this conversation, right? Outside of just focusing on the LGBTQ plus community, we wanted to broaden this and really understand there was some white supremacist activity with that poster. We identified that, right? We wanted to bring in the various perspectives around these issues, okay? And we were very intentional about that. So this is an opportunity to engage the panel and ask any questions that you have at this moment. Thank you.
Hi, my name is Amber. Something that I've noticed just throughout all of the discussions, both today and at the President's Forum and online, is that there's a lot of, theoretical, politically, and, these are the laws, here's what the Constitution says, so on and so forth. And that knowledge is very useful, but what I have yet to hear is, what are we going to do about this? And what can we do about this? Because whether you can fight about whether this is hate speech or isn't hate speech, and what does it even say when you remove the statistics in the picture, and who is it attacking, and all these very academic questions. But what I'm very, very concerned about is that I want to make sure that we can, to the best of our abilities, proactively try and prevent it from happening again. And if it does happen again, I don't want it to turn into another snowball like it has. I would like there to be a framework for it to be addressed. And that's what I've been missing on all these conversations. I would like to know any thoughts you might have on what we could actually do to address this were it to happen again, so we don't have to do this again. Thank you.
I can offer some suggestions. As I've already noted that I think the individuals responsible do need to come before the administration for a conversation. I think some intervention is needed for them. And I also think that this apparently was the first time this happened at Cleveland State, right? So you're now at a crossroads, and I think your question is so appropriate, and I believe that these forums have been organized for the sake of finding solutions and programmatic responses. That said, beyond calling the individual in, having a conversation with key members of the administration, possibly getting them counseling, perhaps you can form a Truth and Reconciliation Council that individual, after an appropriate level of counseling, could attend and participate in and meet members of the community that he or she sought to offend. A lot of times we engage in this type of degrading, debauched behavior because we've had no exposure to the particular communities that we're seeking to deride. So that's one thing you could possibly consider. But I think that you're right, that there has to be a plan put in place to support the community at large, the community that has been particularly impacted by the action, and also the actor in the action.
I guess I would also say that, and I think the university is in the process of doing this, but they clearly need to revisit their policies and be very clear about what's allowed and what isn't. I was trying to find what the policy is in terms of posters and conference services and so on. I had a lot of trouble figuring that out. And even today, I'm not clear about what their criteria are for determining whether something can be put up or not. I think the more transparent they are about that, the better it will be. And I also think this idea of, the content will never be considered in terms of whether it's allowed or not, that was referred to earlier. I think that is problematic and in conflict with other parts. So I think the university needs to just revisit and make clear its own stated policies, and I think that would help to be proactive in case something like this happened again.
I'm just wondering if something could be put in the Code of Student Conduct that deals with this kind of either intimidating or terrorizing conduct or speech, and that maybe a policy where, in terms of the flyers, that if it violates the code of conduct, then it can't be put up, right? So a general code of conduct to deal with this kind of behavior or speech, sending a message that it's not tolerated, but also having practical implications for things like flyers.
Thank you. Questions up
Could
front?
I
Please,
add?
yeah, please respond.
Yeah, thank you. I understand that this is, we're talking about the students, but I think an element that's missing from the conversation is faculty and staff and administration as well. How is it that a code of conduct that we create for the student body, how is it that that same code of conduct and accountability measures are applied to the three groups I've just mentioned, administration, faculty, and staff, so that their behavior and their narrative as it pertains to issues like this also reflects the policy in a way that sends the appropriate messages that to the student body. So if faculty and staff and administration are saying one thing, could be behind closed doors, could be, chats at the water cooler or in the washrooms, how is that being monitored? Because I can attest that also gets to students, and that also has an influence on the behavior of the student body. So I just wanted to add that.
And I can interject that the university's policy against discrimination, harassment, sexual violence, and retaliation, it says the policy applies to all students, employees, visitors, and other individuals participating in university activity, educational, for employment opportunities or programs. So those groups are covered by the policy.
Perfect. So please,
I
yes,
just wanted
question,
to
next question. Mhm.
ask, as I'm learning all about this, if any of the panelists or anyone else at this table know who's doing it well. So like CSU has, its own unique, presence here in Cleveland as an urban, commuter college and all the stuff that we love about it. So we are joining with all of you to address the issues that I think I care about too. And I'm like, okay, so what are we going to do? Who are we looking at in terms of who does it well? What college, university? We have the smartest people, the lawyers, the professors, but so who's doing it right?
I would urge you to look to the universities and colleges on the coast, on the West Coast and the East Coast. I would look to NYU. I would look to Berkeley, Stanford, UCLA. We are in Middle America. We tend to be the last to get news. I would start on the coast and go there.
Anybody else want to respond to that before we move on? Any other recommendations? Kylie, do you have any recommendations of who's doing it well, the work that we could look at as a model?
I would absolutely agree with looking at some of the coastal universities, and I think we could go through those and look at some examples. At this point, it's really an issue of clarifying, I think, on the imminent threat and that how that's going to be considered, and that it's not going to be acceptable regardless. And again, revising policy to say that again, content won't be considered as long as a threat is not in play.
Okay, thank you. I see several questions, and we're going to catch them all. But in the back, yes.
I'm Alex Roth. I'm a graduate student here, and I actually had two questions. One I think might have been potentially a couple of you can answer it, but I was curious about, because the nature of this is a public university, and what about like private spaces within public universities that can be used almost as like, potentially conduits for safe spaces for hate? And the other thing is that we've been focusing so much here in terms of the posters, but there's also other aspects in which this stuff can get out, like the internet and media. And what is the university going to do about speech that goes out that way? Because I don't think we've touched that at all in this meeting.
Any of our panelists want to respond to that first?
I hate to dominate the conversation, but it seems that the policy also applies to the internet in anything. I think the issue is it a CSU student, faculty member, employee, or whatever engaging in that conduct, and is that conduct directed towards this community? So I suspect that is the standard that would have to be applied when you encounter that kind of situation.
This isn't a very good answer, but I guess the only thing I can say is I'm sure that the law is different. I'm sure there's case law regarding social media, more private speech on campus. I know certainly the university has more power to restrict its own speech or speech under university auspices than it does private speech. So they could prohibit something on a university bulletin board that they might not be able to prohibit somebody just carrying a sign on campus. So, but in terms of, I wish I could say I was familiar with all that case law that I'm sure is out there. I could try to do some research or whatever, but so I don't know, but I think that's I'll make that general statement that they do have less power to restrict private speech than university speech under university auspices.
Okay. Anita.
Thank you, Dr. Snett. I'm Anita Gray, the Regional Director of the Anti-Defamation League. One of the things that we do annually is conduct an audit of different events, and I can tell you since Charlottesville, we have counted through September 30th, 79 incidents on 34 campuses of white supremacy recruiting. And we're sitting here in November. I can tell you that's only what we know, and I suspect there are a hell of a lot more, but I don't think that we should make the assumption that the perpetrator in this instance came from CSU. It's been my experience that a lot of these people come out at night, so to speak, and then crawl back under their rock.
Thank you. Yes. Thank you, Anita.
Hi, my name is Lauren Davis. I'm an advisor here on campus in the Honors College, and recently had the privilege to attend a conference at Bowling Green State University that focused on diversity, equity, and inclusion, particularly in honors colleges, but you know, I think that the conversation that happened there spreads more broadly, and that really has a lot to do with the important cultural shift that can happen when we have these kinds of conversations. And while the practical work needs to be done, that educating our campus community, which has sort of been the rock that I've been standing on since all of this began and will continue to stand on, and that is educating faculty and staff about our various communities across our campus, so that we can engage and interact with those communities in a way that's sensitive and compassionate and empathetic and supportive. And I think as that happens, a cultural shift then can occur, which allows for us to stand much more united than we have in these last couple of weeks when something like this occurs. And one of the things that really came out of that experience for me was in thinking about how do we do that? What are we doing in our classrooms to prevent this kind of rhetoric, this kind of speech, allowing it to just slide under the radar? What are we doing as an educational institution? You know, what kind of language, when I'm teaching students, am I using? How am I interacting with them? What kind of material am I teaching? Am I incorporating diverse material from folks all over the country and beyond, and from all kinds of communities? And I just wonder, with the incredible amount of knowledge in this room, what kinds of things do you suggest that we do at that level? Because I think at this point, identifying who did it is a priority, but I don't know anything about that process. And I think people would like to know more about that process. But what I do know is what I can do as an educator. And I just wonder, what are your thoughts on what do we do to interact and engage in a way that allows our whole campus to shift?
Thank you. Let's Kylie, do you want to respond to that first? Of what we could do, providers were suggesting, yeah.
As I understood the question, the question was what can be done from a campus perspective or a general environment in the campus perspective to try to push back against this kind of hate speech. I mean, a few answers that I would say would be, a strong showing of support on behalf of the university towards, targeted groups, including the LGBT community, including, persons of color. So I would say the preferred name policy and the gender neutral bathrooms that were mentioned earlier, those are kind of specific to the LGBT community, but that's a nice move of support. I would say the more the university can do to show inclusion with these communities, the better. I mean, obviously this poster is an attempt to break ranks or to try to break the spirit or threaten, people in the LGBT community. I would suggest, pushing for more support rather than the opposite. So show these students that they're valued, that this is a safe environment, they're not going to be subject to violence. So I would say, definitely a showing from the university of support on behalf of these targeted groups.
Thank you. Other panelists?
I mean, as a teacher, I try to make clear in my classroom that there's rules of civility and respect for all students. So if someone were to say something hateful, I would point that out and talk to that student and make sure that know that that's not acceptable behavior, that that's a condition of life at the university. And then in what I teach, I try to encourage critical thinking and thinking about diversity and those things as well. So I think it's up to each professor to do it, but that's a priority for me as well.
Any other questions from the audience? Yes.
I'm a professor also, but the tweeting and the bullying and stuff that we don't know about goes on. And I just, really respect people that come forward, but some people are just afraid to come forward, and we need to have something in our policy that I agree that we should have, you know, even tweeting, emailing, because we don't see that. And we can do all we can in the classroom, but it's going on.
And we'll take two more questions. So I see one here and then one in the back first. Let's start there, please. Yeah.
Hi, my name's Ariel. I know we've spoken a lot about policies that can be put in place in order to prohibit such speech or posters and such, but the fact was that this wasn't an approved poster, so what can we do to make it so that unapproved posters or unapproved speeches can be limited? What is it that we can do to prohibit the unapproved posters and maybe get to them faster, in a faster manner, so that people aren't seeing them all over the place, and then we end up in a big room like this with a long discussion.
Anybody? I don't want to, yeah.
I'm not really sure what you can do, because you don't know when these actors are going to come forth. All you can do, sadly, is be reactionary and responsive. Again, as Anita said, we should eradicate the presumption that this person was from CSU. But if they are from CSU and they are discovered, you will attend to it. And in doing that, you send a very clear message to members of your community that that kind of behavior is deemed inappropriate, unacceptable, and will not be tolerated.
Last question up here.
Hi, my name is Simranveer Kaur. My question is that we have talked a lot about what we can do within the framework of the First Amendment. We've talked about passing policies from the viewpoints of intimidation or terrorism. And what I want to ask is, what are the next steps? What do the panelists think would be ideal next steps for moving forward, so that instead of discussions, we can see some action to prevent things like this from happening again?
Let me, and again, you know, I'm not in an academic environment regularly, but I can tell you from the perspective of the community, when we run across this kind of intimidation, one thing is, you know, is to be, how do you feel, how do you generate an atmosphere of power? And because that's critical, and the way to do that is through education and awareness. And going back to my initial opening comments, in terms of just a simple thing about speaking American versus speaking Spanish, for example, how is it that we are able to promote the fact that speaking Spanish is legal in this country? That's a very hands-on approach. That's about creating awareness within your spheres, whether it's a student group, whether it's a particular classroom, particular class, is to create the sense of ownership of where and control of where you're in. So that's what we do. I don't know how you could massage that to fit within the context of what we're talking about this afternoon, but clearly that level of self-awareness, camaraderie, solidarity, those types of things with one another that will push back against these kinds of acts.
I guess the only thing I might say is, from the administration's point of view, that if you could set up some kind of protocol to figure out how you respond, so that you're not reinventing the wheel every single time this happens. That basically you got to acknowledge that this will come up again at some point, and then be proactive in laying out steps of how to respond. So maybe laying out some protocol might be an effective way of dealing with, anticipating that this will happen, and then dealing with it effectively.
And I would say, as members of the LGBTQ community, you need to be organized. You have been a part of these discussions now. I would get together, lay out your expectations, even your demands, and then present them to your administration
in a very clear way, if you have not done that already. I'm seeing some eyes roll, so perhaps you have. But, you know, it's really incumbent upon you to keep the fire under them. I have no doubt that your administration wants to respond and will respond, but it's about a conversation. It's about a negotiation. And if you want to influence the policy, you definitely have to have a clear understanding of what your expectations are.
I don't really have much to add, but you know, it's a combination of this kind of education we're talking about, and also protocols. And the last thing I would just say would be policies too, and making sure that university policies get revised in light of these things and be made transparent. And so, I think it's got to be a combination approach.
Excellent. Thank you. Thank you. Let's put our hands together for the panelists. Thank you so much. Thank you again, Kylie, for joining us virtually. I sincerely appreciate that. Let me give some closing remarks and kind of let you all know what our next steps are, okay? Because this was a working planning session, and we have been busy working behind the scenes. And so I think it's now the time to provide clarity and what we're doing moving forward, okay? So after this, we wanted to have this conversation so that everyone would know where we were at, what we were processing, what we were thinking about the law. We could have a shared understanding. After this panel discussion, we are moving forward with revisions, modifications. They're going to be put in the process, and that's already happening. The Office of General Counsel has already been moving on looking at our current policies and procedures. They had started that long before this unfortunate situation happened, but we are continuing to move forward with that process. And so all of the revisions and modifications and suggestions are being carefully reviewed and taken under consideration. Once that is kind of solidified, we will provide that information to you about where that's at, a timeline of events of what's happening. In addition to this large group, we have decided in order to make sure that we hear all of the various voices and opinions about this issue and to gather as much information and talent and resources, we're going to break this thing down. We're going to have smaller forums after this, starting in December, that we will actually provide with you the information about the process of where these particular procedures or policies are at. And the position is clear, and let me say this, the university's position is crystal clear on this. I mean, we're just going to make sure everybody is on the same page. We are an institution that does not condone hate, period. I mean, but now we want everyone to understand that, what that looks like, and that's where we're going to provide that information regarding the policies and procedures in those smaller group settings. Now, in addition to that, we're going to solicit your help, okay? That's when I had made a commitment that the community, you would be involved in co-constructing programming and training as we move forward. That's where we are going to invite you to once we have these various smaller forums. Why did we have this one? I want to provide clarity around that. This particular panel discussion working session bubbled up out of the conversation that we had with the student leaders and the external community organizations that we said, you know what, we want to provide a space for the various stakeholders to come, representatives to come to a meeting so that we can hear about the law and then start moving forward on what we can do and being productive. We wanted to also broaden this conversation. We didn't want to continue to focus on the LGBTQ+ community. This was about white supremacy and racism as well. And so I want to be very clear about that. We are shifting gears here. We're widening this. We're changing and reframing this conversation. This is why we had a diverse panel talking about the issues with the Hispanic community, African-American community, the religious intersection with all these issues. So when you come to these smaller forums, I want you to come with that lens, to view those smaller forum sessions through that particular lens. So again, next steps. We're going to have smaller sessions that will be announced. They're going to be posted on the website. It's going to start in December. We're going to invite about 30 to 50 people per session. Again, we want those to be manageable because we want to hear you. We want to be able to get feedback. During those sessions, we're going to provide you with the updates on where those policies and procedures are at within the process. Again, these things do not happen overnight. Policies and procedures have a process that they have to go through, but we are committed to being transparent about where they are at in the process. In addition to that, we want to walk, as they say, and chew gum at the same time. So while we're waiting on the processes and policies to be developed, what are the programs? What are the trainings? What types of intervention can we start to execute now? So that's what we're going to outline, and you can look forward to seeing all of that information on the website, University Engagement. In addition to that, I know there were some questions that were raised on today that the panelists could not adequately answer regarding the current state of our procedures, this, et cetera. What are we doing? If this would have happened, how would we have responded? I want the students and faculty and staff to understand that we have people who are willing and ready to answer those questions outside of this setting, to let you know exactly where that's at. Shannon is in the back. Dr. Shannon is in the back. Please raise your hand there. She is right there. She has been recording those questions that you asked that you might not have felt like were adequately answered because the panelists just couldn't answer all of those. She will provide clarity for that. Her and her team, and Claire is back there as well. The team will provide clarity for you on that. So again, next steps is what are we doing, to your point? We're doing a lot. We're moving forward with looking at our policies and our procedures. They have to go through the process. We're going to be transparent with you about that. We're going to have smaller group sessions to talk about what can we do while that's going on, what can we do now to make this a more inclusive place for all of our students. Are we clear on those next steps? Okay, I thank everyone for your time and the opportunity to be here, and we had a fantastic one.